I am Pragya and I bring to you excerpts from the current issue of Outlook. Outlook looks at two cover stories. One, titled Almost Real but Not Quite. Virtual production can make the filmmaking much cheaper and convenient. But will the AI powered tech also forever alter the essence of cinema itself? Second, titled Paradise Lost. Can we row the shikaras and have the heritage walks? The cover carries the image and words from the visual artist Veer Munshi. He says, "My installation depicts the fast changing characteristics of Indian cities. So I was wondering about the fate of our paradise on earth called Kashmir." A Constitutional Backsliding by Burhan Majid, an assistant professor of law at the School of Law, Jamia Hamdard, New Delhi. The judgment of the Supreme Court in the Article 370 case heralds an ever-increasing disconnect between constitutional law and constitutional reality in post-colonial India. 4 years after the unilateral abrogation of Kashmir's semi-autonomous status, the Supreme Court of India eventually endorsed the central government's contentious decision on December 11, 2023. The judgment exemplifies the Supreme Court's fragmented track record of disengagement with J&K's unique constitutional position. For the uninitiated, J&K stands as the only state that actively bargained the terms of its membership with the Indian Union. This exceptional constitutional arrangement reserved J&K's legislative authority on all matters except defense, external affairs, and communication, which was later codified in Article 370 of the Indian Constitution. Hence, J&K retained a unique and distinct status in the post-colonial Indian landscape, acceding but not merging like other states. Article 370 also recognized the state's autonomy to frame its constitution. The December 11 judgment bypassed the constitution and its precedents. More than the outcome of the ruling, the conspicuous absence of constitutional reasoning in the judgment is baffling. A closer reading of the judgment highlights that the court has complicated a legally easy issue. Contrary to the time-honored understanding, the court held no qualms about obliterating bilateralism in the text and context of Article 370. The court has virtually decimated the will of the people of J&K by ruling that Article 370 could have been abrogated without concurrence from J&K's Constituent Assembly, a prerequisite under the article. Surprisingly, the Presidential Order of 2019 at least attempted a facade of bilateralism, changing the reference of Constituent Assembly to Legislative Assembly in Article 367. Interesting to note here, J&K's Constituent Assembly was a result of adult franchise-based elections, unlike the Indian Constituent Assembly, symbolizing a transition of the residual sovereignty of J&K from the Maharaja to the people. The state constitution was drafted, a fact also confirmed by the report of the Basic Principles Committee of the state's Constituent Assembly. The committee observed the sovereignty of the state resides in the people thereof and shall, except regarding matters specifically entrusted to the Union, be exercised on their behalf by the various organs of the state. Yet, the court refused to accept that J&K retained internal sovereignty, arguing that J&K had surrendered full sovereignty after a proclamation was issued by Yuvraj Karan Singh in November 1949. The court's invocation of the proclamation is self-defeating for two reasons. First, it was meant to oversee the state's transition from the applicability of the Government of India Act 1935 to the Constitution of India. Second, such a proclamation cannot be invoked to overshadow the constituent power of J&K's Constituent Assembly that shaped the relationship between J&K and the Indian Union. For this and more, read the current issue of Outlook.